I run the show here, not you. That applies for today and forever. Stop talking. Reason. I'm trying to protect you from yourself right now. I haven't made a decision whether your request that your attorney be discharged is granted. Just because you want it so doesn't make it so. I make it so, not you. Your attorney is not relieved until I grant a court order.
Your Honor, Amos Stege here for the state of Nevada, appearing from Washoe County, Nevada.
Thank you. Mr. Hillygus, please.
Attorney Steve Evenson, appearing in scenic downtown Fallon, Nevada. And for purposes of two-party consent, I allow for this to be recorded and used. And I am appearing with my client, Mr. Hillygus, who appears to be on another video screen in another location.
Thank you very much. Welcome, Mr. Evenson. Mr. Pitaro.
Yes, Your Honor, Tom Pitaro, appearing by Zoom from Las Vegas, Nevada. Mr. Handte is present also by Zoom up in the Reno area.
Very good. Thank you. Gentlemen, Mr. Hillygus.
Roger Hillygus, appearing in Washoe County, Your Honor.
Thank you very much. Mr. Handte.
Your Honor, good morning. Stewart Handte, appearing at my residence located in South Reno.
Very good. Thank you. All right. This is a time set to discuss setting this matter for trial. I'm disappointed that counsel couldn't work this out, but it happens from time to time. I know that these aren't the only cases defense counsel has. I know the state has other cases it's prosecuting. I also know that we've got holidays coming up, so this year's out. I know people need time to prepare, so the winter is likely out. So the question is, how far out do we move it? Into the spring, into the summer, or into the next fall? The underlying charges were brought in 2019. I understand there was a preliminary hearing, then events happened, case was brought, here we are. Let's start with the state. Mr. Stege, what trial flight or what month of next year was the state angling for to try to get this case set?
Thank you, Your Honor. For me, the sweet spot, if you will, is the May 2nd trial flight. I have a matter in this department and another department on the flight before, I believe it is. I'm also trying to avoid some prep time necessary for a September capital resentencing, as well as just sort of the general summer holidays. So for me, Your Honor, sort of late spring, early summer would be the sweet spot.
Stege, over setting this, he explained to me that he wished to have the May 2nd flight schedule. I told him that I would move my cases in May, and I have plenty of time to do that out of custody, and I'd agree with that, and I'd also ask the court to use that May date. So Mr. Stege and I had conferred prior to this hearing and agreed upon the May date, Your Honor.
Thank you. Mr. Evenson, what's your position, please?
Your Honor, I'm not sure when the May 2nd flight takes place.
Stop right there. Let me answer that. So the May 2nd flight begins exactly as it suggests. It's a 4-week sort of circling calendar. The very first trial in the May 2nd trial flight, which is trial flight 22. Trial flight 22 begins May 2nd. So if this case is assigned to the trial flight 22, it would go either on the 2nd, the 9th, the 16th, or the 23rd, I believe.
Well, that's what makes it so difficult for me, Judge. And I have a senior in high school in Texas. He's graduating at the end of May. And obviously, if we don't start until the 16th or the 23rd, that would cause me to miss his high school graduation and all the attending celebrations going along with that. And I am unavailable at that time. I mean, I'm not trying to be a jerk. If I knew for sure that we would go May 2nd to May 19th or May 12th, and that's the 2 weeks that they want to do this, I'm fine with that. But after that May 16th date, I can't do anything, at least not of this length and nature. So I'm happy to go along to get along, but I would need to know for sure that we're going May 2nd to the 16th.
again, Mr. Stege, is this set for a 2-week trial?
I believe that's what we asked for, Your Honor.
All right. So, Mr. Evenson, let's make sure I understand the concern. The only 2 weeks in the manned trial flight that works on account of your family events would be to actually start on the May 2nd date as opposed to the 9th to the 23rd.
I think we could do the 9th to the 19th, Judge. That window, I don't think. But I know that week is graduation and all the festivities, and I've got all that blocked out on my calendar. I mean, I would appreciate it if we did it from the 2nd to the 13th. But I'm not going to say that the 9th to the 20th cannot work at this moment. So
okay. Well, that's
I'm trying to work with y'all as much as I can.
All right, thank you. You've made my job easy then. It's the order of the court that you're assigned to, and you can tell Jury Commissioner Lane of the court's direction here. You're assigned to trial flight 22. You're to be prepared for trial May 2nd. Now, a couple other pieces of information, and if I accidentally lose someone, I will get you back. I have to go to another screen here.
Your Honor, may I interject?
Just one moment. All right, so the May 2nd trial flight 22, the motion to confirm is April 13th. The administrative order, which identifies the ranking and priority of cases on the May 2nd trial flight, will be March 7th. I'm involved in that discussion on the ranking. I will indicate when we have our meeting in advance of, the judges have our meeting in advance of March 7th, of the concern about starting after the 2nd or after the 9th. I'll angle for a May 2nd start, May 9th being our backup. All motions pending need to be, any motions that have not been resolved already need to be filed, briefed, and submitted no later than April 4th, 2022. I will direct you to contact my judicial assistant, Christy Poole, sometime in the next few days to set a date later in April, but before the motion to confirm on April 13th for a hearing on any pending motions. The idea being that the hearing will inform the parties of the court's ruling on what could be important for strategic purposes with regard to the motion to confirm. So let me say that again. May 2nd trial flight, motion to confirm date will be April 13th. Administrative order is planned to be released March 7th. Motions filed, fully briefed, and submitted for consideration no later than April 4. Counsel are directed to contact Ms. Poole to set a hearing date a couple of days before the motion to confirm on April 13, so that you'll understand the court's rulings in advance of the motion to confirm. Okay, so that's some additional information. Now, with respect to the parties in a case like this, sometimes they want to address the court. Sometimes their lawyers say, if there's anything you need to talk about, you and I will talk about it off the grid, because they don't normally want their clients sort of saying things on an open mic, so to speak. However, if it's, just sort of procedural or logistical, or if your attorney says, go for it, I'll certainly hear you. I'm not trying to be disrespectful. I'm just trying to protect you from yourself. So not you, but anyone in this situation. So counsel, would you mind if your client addresses the court at this time?
Your Honor, I would mind that. I would appreciate the opportunity either to have a breakout room with Mr. Hillygus or to have him text me with what he wants to discuss.
So let's do this. What we'll do is I will go off camera. Everyone can go off camera and mute, and then you two can have an offline conversation. Don't do it on this Zoom call because we can still hear what's happening. So mute yourself and then go call each other, and and then come back and we'll see if that's something. Oh, so he's already doing that. So I'll go out for 10 minutes. I'll come back at approximately 9:20. We'll see where things stand before we'll be in recess until that time.
All right, let's wrap this up. Let's go back on the record here in about a moment. And so, counsel, if you can please wrap up any call you're having with the client, and we can go back on the record. All right, if everyone could please turn back on their cameras.
Your Honor,
Let's just wait for Mr. Pitaro to rejoin.
okay, I didn't know he wasn't back on yet, Judge.
Yeah,
Sorry.
I can't quite see him yet.
I am.
Okay, thank you. Mr. Evenson, would you like your client to be able to address the court?
Your Honor, I will, but I need to make a record first at this time. Mr. Hillygus has informed me just now that my services have been terminated, that he is discharging me as counsel, and that he wishes to represent himself now on the writ and in terms of going forward with this case. And that is his decision. And I have informed him that his time to get in the writ remains the same. He doesn't get the 10 days or so that we've had pass already, and he has to have that writ in, I believe, on or about October 31st or November 1st. And that date remains in place, and he has indicated that he is going forward today at this point forward representing himself. He's instructed me to file whatever paperwork I need to do to accomplish that. I did not get an opportunity to tell him that I would come back and inform you and that there may not be any paperwork to do. But it is my understanding that he intends to represent himself and all of those things, and that all of that is taking place. He wants all of that to happen right this minute. And with that, Judge, I'll turn it back over to you on how you wish to proceed and what you wish to do with Mr. Hillygus on that issue going forward.
All right, so Mr. Hillygus, before you say anything else, is that did counsel correctly identify your wishes at this time?
At this time, Your Honor, I'd like to exercise my right.
Hold on. My only question is, did your counsel correctly identify the substance of your conversation?
I will be representing myself. That's correct, Your Honor.
And you wish to terminate his services?
That's correct.
All right, so here's what we do. First, the trial date, motion to confirm, hearing date remains as stated. With respect to setting a date for the pretrial conference or hearing on pending motions before the motion to confirm, that obligation will be stayed or stopped pending further order of the court. But eventually, we will pick a date for the final hearing before the motion to confirm. With respect
I respectfully object to setting the trial as a 2-week. I need 2 weeks of just defense. So my case will take 2 weeks in itself. So therefore, I object to the setting of this trial at this time, pending discovery and pending motions. There are motions that are pending. This court, as you recall, lacks jurisdiction in this matter, and so did the Justice Court, lacked jurisdiction to transfer this case to the state court. And I'm going to reserve all of my federal rights at this time. This is a federal case. There was a federal FBI warrant issued, and that's exculpatory evidence, which is being withheld by Mr. Stege. My mother was a resident of California. I had changed her address. I had opened a bank in California. I was taken into custody in California, and the California courts have not provided the exculpatory evidence. I've done a public records request with California, and they told me that the Reno police have instructed them not to provide me any documents that they used to take me into custody. They accused me of being a fugitive from justice, which is false. I was legally in California with my mother as a resident. This case is a federal case. This court lacks jurisdiction. And I will be providing this.
Stop right there. Again, I'm going to tell you a couple of things, Mr. Hillygus. Number one, from now on, you do not address the court unless I call on you or you ask the court permission. You don't just start talking. I run the show here, not you. That applies for today and forever. Number one. Number two, stop talking. Reason, I'm trying to protect you from yourself right now. I haven't made a decision whether your request that your attorney be discharged is granted. Just because you want it so doesn't make it so. I make it so, not you. Third, we're going to set this for a hearing next week. Your attorney is not relieved until I grant a court order. I'll take up the issue of whether he will be fired and you will be able to represent yourself next week. Fourth, right now the trial date stays on. Right now the deadlines the court gave remain standing. Right now it's, as I said before we took this break. That's the order of the court. Counsel, when this call ends, you are directed to contact my judicial assistant by email and set this matter for a hearing on Mr. Hillygus' request that Mr. Evenson be dismissed as counsel and that he be allowed to represent himself. If next week doesn't work, it'll be the following week. Until then, Mr. Evenson, you remain counsel of record. Mr. Stege, is there a position you'd like to state for the record?
Only to ask the hearing, would you like that in person or over Zoom, Your Honor?
Well, it's best to have it in person if we can do it. Let's
agree.
check everyone's calendar and ability to be here because this is an important hearing. Oftentimes, if there's a hearing like this, Mr. Stege, you're during the back and forth with the defendant and his counsel in the court, you are politely directed to remain outside. And those proceedings will not be open to the public other than as allowed by law. All right, so probably in person. So set it for a hearing. Mr. Hillygus, I stopped you because I don't want you to say anything that could work to your disadvantage on this case going forward, whether you end up representing yourself or get new counsel. Set it for a hearing, counsel. I'll see you next week or the following week. Default position is in person. The date set for trial remains as is. That will be the order of the court. Thank you, everyone. The court's in recess.
Your Honor, you haven't got to Mr. Handte yet. Could you, Ms. Clark, could you go the vote? We still have Mr. Handte to deal with.
The judge is gone. Let me try to get him back on. Just a second.
Good.
Counsel,
Yes.
I'm sorry to interrupt, but I am unable to reach the judge right now. So we're going to terminate this. If you have an issue, we'll go ahead and address it at the next hearing.
All right. Well, on the next hearing, if we're going to ask to be then excused from that hearing because we have not made that motion, and this there would be a personal issue between Mr. Hillygus and his counsel, generally in private, that we would probably be on it. And two, I didn't get to
Counsel Pitaro, I can't make that decision. I can't excuse you from it, and only the judge can. I understand your position. If you could please send an email to his administrative assistant, and then they can deal with it that way.
Yeah, that email. And just so everyone knows, I'm in Las Vegas. I'm not going to be able to fly up next week for doing it. Anything with Mr. Handte, it would be easily done by Zoom. There's no need for an in-person as far as me or him. So if in fact we have to do it, I'm going to tell them we'd want it by Zoom. But right now, this motion is just Mr. Hillygus's motion with Mr. Evenson and Mr. Stege. We shouldn't even be involved in it unless he then decides what he's going to do. And we'll just deal with it that way. All righty.
Thank you, everyone.
Thank you.